Guys, how you doing? Once again, not much to say to start out with. I'm certainly glad that we're done with the presentation of evidence. That's always good, so at least we know what we're facing. And, this is sort of the fun part of the trial when I get to argue as though I think people listen to me. That's why we went to law school, but I know in reality it has nothing to do with evidence, but at least I get to try and put it together. We'll do that next couple of days and let the jury make their decision. Questions?
The George Zimmerman decision not for him to testify, tell us about that. He seemed hesitant, was he, and how did you get to that decision?
Well, it's strange because for a year and a half he's been in hiding, trying to deal with everything that he has to deal with because of this onslaught of prosecution. And now we're done, and a big part of him wanted to get in front of the jury and talk to them and say, this is my story, this is what I've done, this is why I did it. And really wanted to sort of give his side of the story. So it was a very difficult decision for George to make. We talked to him, and again, like I said to you guys before, with the evidence the way it is, I think that we have a very, very good chance with the jury right now, and with the evidence as presented. He's already given his story or statement 5, 6, 7 times now, so the jury has that, and we just decided that there was enough evidence in there that we didn't need to present anymore.
Was he leaning towards wanting to testify, and that you had to suggest to him that would not be in his best interest?
Well, I think he wanted to tell a story. I think that he really wanted to be able to interact with this jury and say to them, this is what I did and this is why I did it. And as importantly, this is what was happening to me at the time that I decided to do what I had to do. So in that sense, yes, I think he wanted to tell a story. We give the doctors the scalpels for a reason. We look at, and trust those, and I think he trusted us in the way we looked at the case and where things were. And I think that's the way the decision went in his mind.
Why did you never bring the marijuana evidence in after you worked so hard to get the judge to allow you to bring that?
The what evidence? I'm sorry. These things are a judgment call all along the way. I think that it was relevant evidence. I don't think that it would have been. I agree with the judge's final ruling that it should be available to us should we decide to present it. And that's what the judge ruled. At that point, we knew we had the option. Then you fit that into your game plan, or you fit it into what you're looking at. I think now that we're done with the evidence, I hope that everyone understands. I hope that they believe that we presented this case in a way that did what we could and what we had to do to defend George zealously, but still protected the memory of the loss of a 17-year-old son of 2 people in that courtroom each and every day. So we had to sort of focus what we had to present to the jury in context of trying to be respectful to the event that happened late that night, in a rainy night back in February 2012. And I think that impacted on the decision a lot.
What would be your argument against the lesser charges being pleaded tomorrow?
But it doesn't apply. Self-defense is self-defense to everything. Self-defense to murder, self-defense to manslaughter, self-defense to battery. What happened out there was not a crime. So in that context, there shouldn't have been a second-degree murder charge, and there shouldn't be any lessers. In addition, I don't believe that factually a manslaughter charge would be presented. What George did was an intentional act in that he knew he was pulling the trigger. The reason why he did it was self-defense, and that doesn't suggest a manslaughter charge would be appropriate.
Is that a preview of your closing?
No. It's going to be much longer.
No, I know that.
Mark, you said that you weren't going to want to respect Trayvon by not bringing up the marijuana, but you were prepared to bring in the text from his phone and the photographs.
No. In like form, we wanted to make sure that that was our decision in order to make that decision. And I think that the judge should have left that up to our discretion, but I certainly respect her decision. I think that, again, that I'm not going to revisit a court's ruling. I respect her decision. We had our reasons for wanting to have that as an option for us, and I'm fine with moving forward the way we are.
Do you think the actual animation will be used in your closing statements tomorrow? Will you use that?
Sure, I believe so. Why not? It's a great piece of demonstrative evidence or tool to give the jury an idea of what was happening that night. We now have You know, I think the Vantage Point movie connection that Mr. Root said is perfect. What we have is a lot of different people hearing or seeing a lot of different things, and I want to present it in sort of one cohesive form to the jury. I think they probably get it, but, you know, we have our toys and like to use them sometimes.
Mark, what's your client's state of mind knowing that his fate will be decided in just a couple of days?
He's very worried. I mean, I think he's happy with the way the evidence got out and that he's finally had an opportunity to have his lawyers present his case for him. But, you know, we still have a case where the state of Florida is trying to put him behind bars for the rest of his life. That's a very scary position to be in, and he's worried.
Mark, adding to that, how does Florida's 10-20 life law come into play here with this as self-defense?
It doesn't. They need a conviction before that applies. So we're going to deal with that if we have to. But certainly it just adds to the stress and adds to the fright of somebody who acted in a way where he had to do something he had to do to defend himself and to protect his own life. And now the state's trying to take away his liberty. We'll deal with it.
What's the strongest part of your case? Do you think, like, if you could look at how you presented your whole case, what do you think you hope the jury goes back with in their mind? What do you think you would want people to think about your case?
That George had no alternative, and he did what only that he believed reasonably that he had to do to protect himself from great bodily injury that was already being visited upon him. And if we presented evidence that helps the jury understand that, then we've done our job.
Do you expect more rebuttal evidence from the state tomorrow?
No, we're done.
What happened with Crump?
We're done. There is no further evidence. They've made the decision not to move forward. We've both rested, and my understanding is that there is no further rebuttal, nor is there any surrebuttal.
What happened with Crump? You tried so hard to get him deposed and...
Again, one of those judgment calls. I don't mean to keep going back to the same answer with different questions, but the reality is we wanted his testimony, we wanted him as a witness, we wanted his deposition. Now that we have all of that, we fit that in, and had the decision been made to present him, we would have, but we had to fit it into the overall context of how you present this particular defense case. There are 200 witnesses identified and 80, I think, or 75 called, so there's another 125 witnesses we decided not to call.
Mark, question.